And furthermore, this was actually a very ordinary case in the sense that there was not a lot of detail required. I mean, it's the 3 motor vehicles and it's the alleged loan from Atlantis Nissan. There's not a lot of transactional investigation that needed to be done at that stage.
He then goes on, he says, you should have investigated and the prosecutor should have appreciated and realized this difficulty when police could not serve the search warrant, which according to the regional head was prepared after discussion with the NDPP. But it appears they did not, and neither did the regional head. Am I correct in understanding that the search warrant became irrelevant because they cooperated?
That is correct, yes. And one must just remember that search warrant was issued by a magistrate after reading affidavits, and he was satisfied that he complied with the law and he could grant that search warrant.
And nobody tried to impugn the credibility of the magistrate in granting that search warrant?
Nobody.
Right. And that's not the subject matter of the complaint that had been lodged either?
It was not. I think the one complaint Advocate Mrwebi had was about the magistrate to sign the warrant of arrest, which is not this one.
But that's not in
but only the IGI could investigate it.
Right. But if I take you to the last sentence in paragraph 3 of your memo, can you just explain that?
I say, however, only 2 paragraphs of the entire representations consisting of 47 paragraphs find any reference to or bearing on the corruption and fraud charges. We were provided with 2 sets of representations, and I think we made a mistake here. What we're referring to here was actually the murder representations, which consist, I think, of 47 paragraphs, not the representations to the special director. But in any event, I can confirm that the representations made to the special director also did not include the aspects that we referred to.
When you talk about the representations of the murder matter, we see that is at 47 of the record, and those are the representations that was made to the DPP. Actually, it went to the NDPP of Public Prosecutions on the 26th of October 2011.
That is correct, and I think here we are referring to paragraph, to that 47 paragraphs.
Right. And maybe if I then take you back to the representations that were made in respect of the charges under, let's call it CAS 155, right? And if we skim through those, we will see that in paragraph 6, let me take it back. In paragraph 2, they identify it as relating to the purchase of some vehicles, correct?
That is correct. That is on page 37.
Right. In paragraph 6, he identifies how the arrest was handled, and it describes in the same way your practice that you told us about early. He received a call and he went with his lawyers with a bail. And are you aware of any other aspects that actually deal with the merits of the claim in the matter other than process?
No, but he does in paragraph 28 state for the record that Mrwebi denies the allegations made by the state against him, and we are of the firm view that the state does not have a case against him.
Well, that's not sufficient. Every accused can basically make representations that say that. That's not a basis upon which, well, they may not put evidence in your mouth. Is that sufficient upon which dealing of merits for purposes of representations?
No, not at all, and I think that's why Advocate Smith in one of the letters state that the representations didn't deal with the merits. So therefore, initially, he also didn't deal with the merits. It was an abuse of process and police fabricating evidence, etc., but not on the merits of the actual complaints.
In paragraph 17, he complains about how long it took for the warrant to be executed. And then in paragraph 19, I think he refers to the warrant being signed by one Advocate B. Smith, who develops policies in the office. He's got the wrong person, doesn't he, Advocate Ferreira?
Yes, which is very curious, because by then he had appeared in court and he would have met Advocate Smith, who actually was the prosecutor placing the matter on the roll. They had it completely wrong. It was Bradley Smith, who I know well, had nothing to do with this matter.
So in effect, the complaint in paragraph 20 related to the alleged conduct of the investigating team in seeking to fabricate and manipulate evidence against Advocate Mrwebi, which would result in an unfair trial. Is that correct?
That is correct, and I mean no evidence of that was produced. In other words, there was bare allegations being made against the investigation team, but there was no substantiation thereof so that it could be investigated properly.
In fact, if one looks at paragraph 21 of the representation, he acknowledges that it relates to the purchase of vehicles for crime intelligence and that the person responsible for that function was Colonel Barnard. If there's any criminality with regard to such transactions, he would have to be the one to explain, as he is responsible for those vehicles, correct?
That is correct, yeah, and perhaps before I forget it, what's curious here is that Barnard never made representations. However, the case is withdrawn against both Mrwebi and Barnard.
So even though Advocate General Mluli in his own representation say if there's anything to be answered against anybody, it would be Barnard. When the ultimate decision gets taken, charges gets withdrawn against Mluli and Barnard.
That is correct, yes. And then perhaps the only other reference to the merits perhaps is in paragraph 27 of the conclusion that I read out previously, where he says that they should decline to prosecute irrespective of what the merits, what may appear to be the merits of the case against him. That's the only other reference to the merits.
Right. So then I take you back to your memorandum, and you basically explain in paragraphs 4. Let me not put words in your mouth. Tell us what was your thinking and take us through the memo.
Okay, I think I would not want to read out the whole memo, but I can basically explain without reference specifically to specific paragraphs. There was a number of issues. The first issue that I think we raised was that Advocate Mrwebi could not take the decision, and if he did take the decision, it was an illegal decision because he was not empowered in terms of the NPA Act to take the decision. The reasoning for that is basically just the following. We reported to the Director of Public Prosecutions when the prosecution was instituted. It was instituted by us on behalf of the Director of Public Prosecutions, Advocate Mzanyati. Therefore, it meant that nobody except somebody with a higher rank than Advocate Mzanyati could interfere with the prosecution. The fact that Advocate Mrwebi was at that time appointed as a special director did not mean that he can go to the director's office and interfere with the cases that the director was busy with. And that was our main concern. In other words, it was not a case that Advocate Mrwebi was dealing with that he could describe as his own case, or a case on which over which he had authority, and therefore the representation should have been made to the Director of Public Prosecutions, Advocate Mzanyati, who was the functionary dealing with that matter. Then secondly, we said that irrespective of that then, if we are wrong on that, and Advocate Mzanyati, Advocate Mrwebi was entitled to deal with the representations, then the NPA Act says that he must do so in consultation with the relevant director of the relevant province, which he obviously also did not do. I know there's a whole bunch of controversies, not for me to deal with, of whether there was in fact consultation or no consultation, and I think the disciplinary record of Advocate Breitenbach's before the court, as well as it was dealt with extensively in litigation.
But the point is, in paragraph 21.5, you raised this expressly in the memorandum.
That is correct, yes. And I think also on that same page 119, there's a whole section that we deal with the legality of the withdrawal instruction. And I think what I've just mentioned is basically paragraph 21.4 and further. We also then, paragraph 21.5, I think there we say, the requirement for consultation, as envisaged in section 24.3 of the NPA Act, are therefore clearly only relevant in circumstances where the special director or his staff contemplate the prosecution in the area of jurisdiction of a DPP, and are certainly not meant for a scenario where the relevant DPP is busy with his, and inverted commas, his own case in his own area of jurisdiction. So yeah, the first point was he was not entitled to make the decision or interfere because he was interfering in the authority of the Director of Public Prosecution. Secondly, if we're wrong on that score, then we said a proper consultation in terms of section 24.3 did not take place, and therefore the instruction was also not correct.
You then proceed to deal with the Inspector General in paragraph 24 onwards of your opinion, and effectively you set out that he was wrong from inception in his view on the involvement of the Inspector General. Is that correct?
That is correct, yes.
In fact, this was borne out by the correspondence which was sent by the Inspector General prior to this memorandum being prepared, correct?
That is correct, yes. And then in the next section, perhaps before I forget about that, we deal with unwarranted attacks on state officials.
Can I just take you back? Before we get there, in paragraph 24.7, you specifically deal with the Inspector General not conducting court-driven investigations. Is that correct?
That is correct, yes. I can perhaps, if you want to, I can say, I read it out. The Inspector General does not conduct court-driven investigations, nor does her office have any capability or mandate to conduct criminal investigations, which this clearly is. And it is clear that the Inspector General has never referred a criminal case to the NPA simply because the NPA cases emanate from the South African Police. And that was also because of meetings that the investigating officer with Advocate Breitenbach had with the Inspector General. I was not part of that, but that was what was conveyed to me, and it was included in this memo.
Right. Now, you then deal with this unwarranted attack on state officials.
Yes, it seemed to me...
Before you deal with the substance, are you aware of any of the persons so attacked in the representations being asked for their version of the events?
No, not at all. Not the police and neither the prosecutor, Advocate Smith, or anybody else. It had, like we say there, over the last 12 years of the NPA's existence, it's become clear that the favorite strategy of the criminal accused, more particularly the guilty ones, has been not to attack the case against them, but to attack the integrity of the prosecutors and to blame them for being part of the conspiracy. I think it was clear, there's Canadian articles on it, that it happened there first, specifically in white-collar criminal cases. If they can't play the ball, then they play the man. It has also led in South Africa to the removal of prosecutors from cases on the application of accused, etc. Our feeling was at that time that one must obviously be careful to just take the word of an accused or a criminal, an attorney or an advocate appearing for such an accused, and the NPA should be careful not to just accept as the gospel truth any allegation being made against any prosecutor without proper investigation and without making sure of the facts, because it would be blatantly unfair against the prosecutor if he's attacked merely on the say-so of an accused who has an interest in perhaps bad-mouthing the prosecutor or getting rid of the prosecutor. So that's the area there.
And you then sum up your concerns about the decision in paragraph 28 on page 126 and onwards, essentially saying what you've just told us. Correct?
That is correct, yes.
Right. You then deal with the legal effect of the decision in paragraph 29 onwards.
Perhaps importantly, paragraph 30, we say there, we submit that it's not even necessary for you to determine whether the decision by the SDPP is correct or not. You should instead ask the question whether the decision is justifiable. If you can find no convincing reasons that the decision was reasonable, then it should be overturned.
And you then detail what the NPA policy considerations are in paragraphs 32 to 37, correct?
That is correct, yes.
In paragraph 37, you point out it is contended that the public interest demands that the Mluli and Barnard be prosecuted in open court, lest the NPA be accused of only paying lip service to the government's declared war against corruption, or is the impression that such war and corruption is completely dependent on who you know and what you know. Can you elaborate on that?
Yes, there's another place where I think we referred to that. The previous page, if you look at paragraph 34, we say once an assessment has been made that there are reasonable prospects of a successful prosecution, the policy dictates that. And we quote from the policy paragraph 4A, once a prosecutor is satisfied that there is sufficient evidence to provide a reasonable prospect of a conviction, a prosecution should normally follow unless public interest or, unfortunately it's not very clear, public interest or
public interest demands
otherwise, yes. Now perhaps just for clarity, I know there's been several versions of the policy, the prosecution policy. This 4A refers to a policy that was adopted in 2006. And I think the policy was changed either in 2012 or 2014 again, but that was after. This was the policy that was in place at the time of this decision.
So effectively what you're relaying in paragraph 37 is, as reading you, and correct me if I'm wrong in summarizing it, is that the public interest is what is you set out in 37 and it doesn't demand otherwise.
That is correct.
Is that what you sought to relay?
That is correct, yes.
Okay.
I think there's an expectation from the public that the prosecutors will prosecute without fear, favor or prejudice, and that the person who is the subject of the prosecution, his or her status, political alliance or otherwise, would not influence the prosecuting authority from executing their duties.
Right. You then detail some of the crime. You say in paragraph 40 that documentary evidence is more than sufficient to prove the corruption, and typically witnesses will be called to hand in these documents and corroborate the documentary evidence. We are now talking about the charges that is on the charge sheet on 155 that you referred to earlier. Is that correct? Were you of the view then that you had sufficient evidence to make out that case?
Yes, the evidence that was available is set out under that heading, and it culminates then at paragraph 39, where we say this is not the sum total of the evidence, but enough to show at the very least that he received an unlawful gratification. Now, if I can perhaps just expand on that, the further problem that we had is that Lieutenant General Mdluli is the head of crime intelligence, which is an extremely important position in an extremely important part of the South African Police Service. Now, he's the head of that. He then goes to Atlantis Nissan, who's the biggest supplier at that stage of covert vehicles to crime intelligence, the unit that he works for, and then obtains a loan from them. I mean, that is bizarre by all standards, because a normal person would go to a bank or a financial institution to obtain a loan. If you obtain a financial assistance or a loan, if you call it that, from the supplier to the unit that you're working at, my submission is that that's textbook case of corruption. We could prove that because we had the acknowledgement of debt that was signed. We had the evidence at that stage from the person from Atlantis Nissan. And that's the one count where we said that that's a definite count of corruption, receiving an unlawful gratification. The problem, however, is that that loan, or inverted commas loan, the admission of debt, of acknowledgement of debt, was only signed, I think, a year after the actual money changed hands. So our view further was that that is actually a disguise for the unlawful gratification in the first place. Somebody felt it was necessary to disguise this money that flowed from Atlantis Nissan to Leo Heiser on behalf of Lieutenant General Mdluli, and an acknowledgement of debt was signed, and it was called a loan. But the definition section of the Corruption Act that deals with this specifically says that the unlawful gratification can also be a loan. We could not find any evidence that Lieutenant General Mdluli went to his superiors to ask permission to engage in a financial transaction for his personal benefit with Atlantis Nissan. But that was not all. The other aspect was then the discount that should have gone to the South African Police Service was then utilized to cover the shortfall to get rid of his private vehicle and with his private vehicle, and then also the further fact that as an SMS member, senior management service in the public service, including the police, you are not allowed to travel with state vehicles unless you are authorized there to by a superior. The idea is that you are given an allowance, motor vehicle allowance, and in terms of the SMS handbook, you are forced to keep a vehicle in good condition so that you can do your official travel with that. The problem further here is that the 3 series and the 5 series that was purchased was utilized by Lieutenant General Mdluli and his wife. And that also bothered us. But the bottom line is, if we had only the one piece of evidence, and that is the fact that he made a loan with Atlantis Nissan, the provider of vehicles to his unit, that would have been enough to prosecute him on and to, in my view, to obtain a conviction.
You then in paragraph 11 of the document, you say that the charges then pending against Mdluli and Barnard were fraud and corruption. And then you say new evidence had in the interim come to light and would require investigation. Is that correct? That's
yes.
You foreshadow that new evidence.
Yeah, that was basically evidence which we can later refer to if required, the evidence of a China trip that was undertook by Lieutenant Mdluli and various other people, as well as a trip to Singapore, and even much more later, further evidence came to light of wrongdoing.
But the subject matter of your memorandum and the subject matter of what was before Advocate Mrwebi and later made representations to did not relate to those issues. Is that correct?
Yes, not at all. This only related to the 3 motor vehicles.
Right. Did you get a, let's go to page 106. Sorry, 108, which is the next document.
Sorry, just repeat the number, please.
108. It's just the page just after your
I have that. There is a memo that advocate, that's the acknowledgement of receipt that I referred to earlier, dated the 26th of April on page 108, where Advocate Mrwebi in the first paragraph says, I confirm that on 23 April 2012 you delivered to my office a document on the above mentioned matter. He then goes on to describe the document. There's no doubt that it's actually in fact our memo. He then goes into the second page, which we found curious at that stage, and then he says he will not allow or consciously become party to any situation where the NPA, the SCCU or any other component of the NPA for that matter is being used or abused for any purpose unconnected with promotion or advancement of the interest of justice or the rule of law under the guise, be it through the purported exercise of investigative powers by the police or the purported of exercise of prosecutorial functions by the prosecutors. Now, taking into account what I've just said about the charges and what it entailed, this was very peculiar to us at the time.
Do you know what he was talking about?
Not for 100% sure, but I think he was talking about the allegations that was made that the police are fabricating evidence and they had the knives in for Lieutenant General Mdluli and they wanted to get rid of him and there was some sort of a conspiracy, but none of that was ever placed on paper in affidavits that one could rely on. Not in the matter that we were dealing with here.
Then he talked about a distinction to be drawn between acts of maladministration and acts of criminality. Was there any information that you were aware of in the docket that dealt with acts of maladministration?
Not at all, but maybe I'm wrong, but I got the impression here that he was speaking about the fact that the NPA is only concerned with acts of criminality, and in his view, in this case, what happened was actually acts of maladministration, and therefore the NPA shouldn't be involved and the police shouldn't be involved. It was something that the IGI should deal with. I think from what I've said, it is clear that one cannot say that it's acts of maladministration. It was criminal acts of corruption that was committed by both Lieutenant General Mdluli and Barnard.
It does then seem in the next paragraph he says nothing had changed in the case purportedly since he had made his initial decision. Did you understand it as that?
That is correct, yes. And then he says, on the contrary, the obvious illegal actions on the part of the police in assessing classified privileged information and placing same through certain newspapers in the public domain, I had no idea what he was speaking about, and I had seen no evidence of something happening. I know later on there was also mention of the fact that the police illegally obtained documents, but the problem with that is the following. A policeman like Colonel Roelofse, who is authorized in terms of the Police Act and the Criminal Procedure Act to act as an investigating officer, goes to crime intelligence and obtains from a policeman, also appointed in terms of the same act as him, certain documentation. It's kept in a police safe, for example. That document never leaves the police's hands. It exchanges hands from crime intelligence police officer to Colonel Roelofse, who's a police officer. How it can be stated, if that is what was meant here, that Colonel Roelofse then illegally accessed privileged documentation, I don't understand, because Colonel Roelofse had all the power to access those documentation. And then I've never seen any evidence that the police, through certain newspapers, placed anything in the public domain. I don't know what specifically he's referred to here. And then the case for the state even more suspicious.
Well, so you're dealing with a paragraph that reads, having been provided with further information on the matter. Do you know what that information was? Or
Sorry, I was just referring to the paragraph just above, the closing
sorry,
of
yes.
that. But then, yes, having been provided with further information on the matter and having been privy to other classified and confidential and high-level discussions with police management, I'm concerned that our actions may be interpreted, justifiably so, as amounting to serious abuse of the legal process and as being motivated by ulterior purposes. I had no idea then, and I still don't have an idea. I've never seen anything, and I do not know who he could have spoken to. It was certainly not the investigating officers or Advocate Breitenbach or myself.
So let me unpack that. You don't know what further information he's referring to?
Not at all. It was never shared with us.
You don't know what other classified, confidential and high-level discussions with police management he had?
No, I don't.
You don't know what abuse of the legal process he's referring to?
Not at all, and I deny that in this case, the actions of Advocate Smith, myself and Breitenbach was in any way abuse of the legal process.
Is it the practice that police management impacts on prosecutorial decisions that must be taken?
Not in the sense that's referred to here. I think it would only have been fair and transparent if that information was shared with Advocate Breitenbach, Advocate Smith and myself, because ultimately we were the prosecutors dealing with this matter until we all were removed at this stage. So it would be important for us to also be aware of this information in any further decision taking the matter forward.
I didn't ask Dr. Ramaiti this question. Are you aware that the special director is given special clearance on security? Maybe it's unfair to ask that. Whether a special director as Advocate Mrwebi had special security clearances, but I think it's not the appropriate business to be asking that question of. I'll make a note. We have to ask somebody that.
Are you withdrawing that question?
I am. He's not the right person to inquire about that. We'll ask Advocate Mrwebi about his security clearance. It then goes in the above your conclusion is in addition to consideration of absence of admissible evidence and a situation where any evidence that may have been admissible had been compromised. Did you regard your evidence to have been compromised in any way?
No, not at all. And I think it's the appropriate point to perhaps just point out the documentation in the possession of Atlantis Nissan was not subject to crime intelligence secrecy provisions at all. It was normal public business records of a motor dealership. In a similar fashion, the documentation by Leo Heiser is documentation of business records of that specific dealership. The acknowledgement of debt signed by Lieutenant General Luli was not a secret document or a confidential document. Those documents could never ever be described as having been compromised or that we would not be able to have it admitted in a court. So I didn't understand what Advocate Mrwebi meant here.
And no details of what he meant was provided? No.
That is correct, no details. And then, importantly as well, the next paragraph, it is a known fact that the Auditor General examined the information containing the alleged criminal transaction by Mndluli and Barnard, and based on the rules governing the Secret Service account, found nothing untoward with the transaction. Now, I have personal knowledge because later on, Advocate Paul Lowe and Advocate Arno Rousseau was appointed by Mr. Nkasana to deal with this matter, and I attended a meeting at the offices of the Auditor General with the relevant people that was responsible here, and they informed us that they never investigated the transaction and they never made a finding that there was nothing untoward. In fact, had this transaction been brought to their attention, they would have raised a management query and it would have raised the red flag. So I don't know who gave Advocate Mrwebi this information, but that person clearly was mistaken because I was part of a meeting that I just described.
And was this information ever in the docket?
No, this is something that transpired after, most probably.
No, I'm talking about when he writes this letter, 26th April 2012.
Oh, yeah, no. There was nothing in the docket that stated that the transactions were found to be nothing untoward by the Auditor General.
So you don't know where this known fact came from?
Not at all. It wasn't in the docket.
Sorry, when was this meeting that you're referring to?
I don't have an exact date, Advocate, but what transpired is first a different sets of prosecutors were appointed basically from August 19. Sorry. Okay. No, I can't precisely say when it was. Sorry, but Colonel Rulofs, who I stand may come and give evidence, was also at that meeting, and he may actually have obtained a statement later on subsequent to that meeting and would be in a position to inform you of the exact date.
Advocate Bauer, can we take a break for 5 minutes just to assist the record takers with the electronics of the system right now? They need a break for 5 minutes so that they can sort electronic issues. Can we break?
Yes.
And if anybody needs to go out, kindly be back within 5 minutes. Thank you. Are we all set to proceed now? Yes, thank you. We are all back. You can proceed, Advocate Bauer.
To answer the question, I do have an answer, but maybe it's just best left for Advocate Roloffse Colonel Roloffse to deal with that. But it was about a month or so later to just put it into. Actually,
That's in order.
a week or two later after that.
Oh, you're answering my question?
Yes.
Oh,
Yeah.
sorry.
Just
I was
so that you
wondering-
can make a note that Colonel Roloffse will deal with it. But on his evidence, it will be about 2 weeks, maybe a week or so later that happened.
Thank you.
Sorry, I
Thank
think
you. You may proceed.
perhaps I must just say there may have been a meeting that he had a month after this, but what I'm speaking about is considerably later, that he will most probably also remember, because that was when Advocate Paul Lowe and Advocate Arno Rousseau had been appointed by Mr. Nkosana to deal with this matter further. And that may only have been very late 2012, or actually 2013 perhaps, or even 14. I can't remember offhand now when Advocate Nkosana was appointed as the NDPP, but I'm speaking about a meeting after the appointment of Mr. Nkosana, and when Advocate Paul Lowe and Advocate Arno Rousseau was the appointed prosecutors in this matter.
Take you back to the letter at page 110. He reiterates and he remains of the view in the last paragraph that this is a matter that must be dealt with by the Inspector General. Correct?
That is correct, yes. He then says in the penultimate paragraph, it is my considered view that it will therefore not be in the interest of justice for the NPA to be further involved in this matter. I once again emphasize that the Inspector General is the appropriate functionary. He ends off the letter by stating he will advise the Acting National Director accordingly.
Right. And then if you look at the next document, it is dated the 8th of the 6th, 2012, and it's a letter, or the 7th of the 6th, 2012, and it's a letter there from Anwar Dramat to Advocate Jiba. Have you ever seen this before? I showed it to you?
Prior to you showing to
Yes.
me, no.
Okay. And this is,
What are you referring to now?
I'm at the next document, which is at 134A of the bundle.
Because we're at 110.
Yes, but there is a gap. As long as our numbers flow, we excuse missing numbers right now.
As long as you, I think you keep forgetting that we must follow you. You must
Details,
lead us.
details. But it's evident from this letter that Lieutenant General Dramat is inquiring from Advocate Jiba as to what's going on in this matter.
That's correct. And on page 134B, in the middle paragraph, he
States that an urgent appeal is once again made to you to urgently review the decision of Advocate Mrwebi and to give your decision in your capacity as Acting National Director of Public Prosecutions on the matter. And that is dated the 7th of June 2012.
Other than the response you received on the or other than the response that was received on the 26th of April, are you aware of any other response to the memorandum which was delivered to Advocate Jiba?
No, I never received the response, and as far as I know, Advocate Breitenbach also not, because a couple of days later, the 30th, she was suspended. Yeah, I never received any further notification from either Advocate Mrwebi or Advocate Jiba as to a response to our memo.
Happens. I then want to take you to page 135 in the bundle. We'll go past all the 134 subsections and we'll go to page 135 in the bundle, which is a memorandum from Advocate Mrwebi to Advocate Mokgotla. Which Advocate Mokgotla is that? Marshal Mokgotla?
That's Advocate Marshall Mokgoro, the acting regional head at the SCCU, who replaced Advocate Breitenbach.
Did you see this prior to me showing it to you?
No.
And essentially this was an instruction which went to him on the 6th of August 2012. This is, 8 months after the decision to withdraw, correct?
That is correct, yes.
Right.
Apologies, what page is that?
135. The 130, it comes after 134S, and then there's a, mine might be chronological, but that's it.
We have it as 137. Does everybody have this page? Dated the 25th of June 2013.
No, it's dated the 6th of August 2012. It's just before that, apparently.
Apparently doesn't have a page number. Yeah, okay. But it is addressed to Advocate Mokgoro, and it's from Advocate Mrwebi. This is that one. After 134Y. Locate 134Y, and immediately after 134Y. You don't have 134Y. Do you? 134. I'm looking for O. I have Mokgoro. No, it's not the one.
Do you have one copy between the three of you? We'll pass up another. Just give you a copy. If you want to keep the file chronological, then it should probably go after 134S.
Thank you. I think you can go ahead.
As it's apparent from the introductory part of this memorandum, it followed on a meeting held with General Dramat on the 1st of August. That's apparent from the document, correct?
That is correct, yes.
Right. Now, it related to in the second paragraph, it is detailed, sorry, let me just read it to you. Of note during the said briefing is my reference to a decision or an agreement between Advocate Mzanyati, Advocate Breitenbach and myself on 9 December, in terms of which it was agreed, decided that in light of the concerns I raised, particularly about the evidence in the matter, the withdrawal of the charge against Lieutenant Mluli was provisional. Secondly, that Advocate Breitenbach would advise the prosecutor in the matter to withdraw the matter provisionally pending investigation and address the concerns raised. What did you understand those concerns that were raised to have been?
That the police do not have a mandate to investigate this and that it belongs to the IGI.
Were there any other concerns that you were aware of that needed to be considered?
I think there was one concern, but I'm not sure that that wasn't actually raised much later, where Advocate Mrwebi says that everything points to Barnard doing everything and Mdluli's hands is basically clean. He's not implicated in the documents. However, that does not take cognizance of the fact that Mdluli signed the acknowledgement of debt from Atlantis Nissan, so it wasn't correct in that sense.
But that didn't appear from the memorandum on the 4th of December.
Not at all.
And that thirdly, she would instruct or request the police to follow up on the concerns raised, and then the matter would be reinstated. What concerns that would be raised would have to have been raised with the police?
I'm not sure, unless it's the concerns about the police not being able to investigate it. I know of no other concerns. I wasn't part of the meeting, and Advocate Breitenbach did not give me any feedback as to anything that must happen next, or any further investigation that must be conducted.
In your view, at the time, was there any further investigations that needed to be conducted in respect of the charge sheet which you had
No, in connection with the cause, I doubt whether there was any investigation left. As the facts that we've set out, I'm quite convinced Advocate Smith and myself would be willing to take that to court.
I want to take you to the last paragraph. Accordingly, I request that your office must please give the investigators in the matter the necessary assistance and guidance as may be required to ensure that the matter is properly handled, and I would suggest that a new prosecutor, uncontaminated by previous developments in the matter, be appointed to guide and take decisions in the matter. What do you understand by uncontaminated by previous developments?
That was not involved, although uncontaminated may be my lack of understanding of the English language, but uncontaminated is more of a negative term. Uncontaminated by the previous developments, which could only mean the involvement of myself and Advocate Breitenbach in the memo, and asking the acting national director to review the decision. I can't think of any other way in which we would have been contaminated.
Were you told that you were contaminated in any way?
Not at all, and this letter wasn't addressed to me, and this was never spoken to me by either Advocate Mogatle or by Advocate Mrwebi.
And no steps had ever been taken against you for acting contrary to the prosecution policy or acting improperly in any way?
No, and I don't think I have.
I now want to turn to...
Sorry, before you leave the document, perhaps just the first part of that last paragraph you read, it also says to give the necessary guidance and assistance. Now, if it's relating to the motor vehicle charges, I don't know, and it is not spelled out here what guidance must be given on the motor vehicle charges. If reference is to the China trip and to the Singapore trip, I had in fact been in consultations with the Colonel Rulofse, and I in fact did give them guidance as to what further information they must obtain on the China trip and on the Singapore trip.
And subsequent to that, you were removed as the prosecutor from the matter, and it was allocated to other prosecutors, correct?
Yeah, I received an email that I think is part of the papers from Advocate Marshall Mogatle saying I've been removed and that I was replaced by Advocate Mashamaite and Advocate Becker, who was a deputy at our office, and Advocate Mashamaite, a senior. I then forwarded to them certain of the information I had available to assist them in looking at how to take the matter forward.
And in fact, that one sees at page 134C. You must go forward, not backwards, because there's two 134s, I think, coming up. There's two sets of them. Why maybe... they follow on after we reach Y, we go back to A. The file follows more or less a chronology, so if you just move pages onwards, you would find it.
Sorry, can you just give the page number again, please?
It was 134C. I think you just need to page one page onwards to find the emails right from where we were.
Now my next document is 137, and that's a memo drafted by Advocate Becker and Viljoen
Okay, we don't need to. I was just. It's not an important document. It's just that the email is there, essentially to tell you what the logistics in the arrangements were.
Yeah, I've been provided with it. It's 134C and 134D.
Yeah.
It is clear Marshal Mokgatle writes to me on the 17th of September 2012, and he copies Advocate Becker and Advocate Mashamaite. Says, Dear Jan, I have decided to allocate the Madluli matter to both Gideon Mashamaite and Andre Becker. Kindly arrange all the handling over logistics with the two gentlemen. Regards, Marshal. I then respond to him on the same day and said to him that the police have removed taken the original BMW docket to make electronic copies, and I asked him whether I should tell SABC that I'm no longer the prosecutor or whether they will inform them. And then there's also 134D, there's an email by Advocate Mokgatle on 17 September where he says, Dear Andre and Gideon, please take note that you have been appointed as the new prosecutors on the above mentioned matter, which was previously handled by Linus and Jan. You are requested to give the investigator concerned the necessary guidance and assistance as may be required to ensure that this case is professionally handled. Best regards, Advocate Marshal Mokgatle.
If one then goes to 134T in the document, which is an email dated 23 October 2012,
I have a charge 134T going over the page to 134U and V. That's an email from me to Advocate Mashamaite, and I address. Should I proceed? Sorry.
You can proceed. We're just making note that our papers, the young lady's papers are fine. Ours are a bit of a mess. But you can go ahead and continue. Just note that. I don't know whether it was an ageist issue, but our papers are not.
I did
About to say, and we need it more than her.
not say that this is a hard copy dilemma that doesn't happen when you do electronics, but I won't throw that stone. But can I say that what we tried to do was forget about the numbers in the moment. I understand that they attempted to restructure the file so that it was chronological and you simply needed to follow the paper. So if I'm now at October 23rd October, your file may help you with a date by just flipping to a space where you can see the date.
Difficulties, for instance, we have 2 134Ts, but it's fine, you can go ahead.
So when I say to you, try and flip through the file, forget about the number for the moment, and just look and find the date on a document that's October 23rd, 2012, and then you may just, so the dates are in order, from the earliest to the latest.
It's okay, I think we can proceed.
Not from the left, so that does appear to be the case. So all you would have to page is a few documents on, and I am skipping a few just because that's evidence and I don't need to lead him through everything, or else we are in trouble today. May I go on? So, Advocate Ferreira, your email, without going into the details, was it was essentially a aide memoir to the new prosecutors as to where you were at with the different cases.
That is correct. Dealing firstly with the BMW charges, and then perhaps just for sake of clarity, the third page of that document, there's a heading to assist you in understanding the Singapore and China trips, and then in brackets, most probably to be prosecuted in a separate trial, separate accused, the following. And then there's a Littleton CAS number, and then I go into detail, which is I suppose not necessary, regarding the two trips, who was, what offences may have been committed, and who the possible accused may be, and also what further investigation I believe at that stage may be necessary.
And so that Littleton CAS number is what you believe to be what the other charges were under?
Yes, but like I say, I don't have an independent memory what that CAS number entailed, but at this stage I clearly believe that it had to do with the China and Singapore trip.
Right. Okay. Now, after that, did you have anything further to do with the Mrwebi investigation?
No, not until until the new NDPP was appointed, Mr. Nkosana.
You must be specific, there's lots of new NDPPs.
No, Mr. Nkosana, when he was appointed, I don't know how it came about, but he wrote a letter which I don't have possession of, where Advocate Paul Low, a deputy in the SCCU Pretoria, Advocate Arno Rousseau, a senior advocate at the DPP Pretoria. I'm not sure about Advocate Broughton, but I think he was included, was appointed to deal with the whole Mrwebi case, and it was mentioned that I will be involved only for institutional memory. Like I say, I then attended a meeting with them at the Auditor General. I also attended a meeting in Cape Town with Mr. Colonel Roelofse, and both the gentlemen I've just referred to. And I think that's the sum total of my involvement in the Mrwebi matter.
So by that stage you became uncontaminated?
Yes, and as soon as Advocate Low and Advocate Rousseau was up to speed with what happened and the investigations, etc., I withdrew and they carried on with it.
Right. Now, in the course of preparing your affidavit with you, I showed you an affidavit which had been deposed to in the, what we'll call the GCB matter. Is that correct?
That is correct, yes.
And I raised certain paragraphs in that affidavit, and I asked you for your opinion on those paragraphs. Is that correct?
That is correct, yes.
And was that the first time you had sight of that affidavit?
Yes.
And that one picks up from paragraph 27 of your affidavit on page 6 of the typed document. And I'm not going to take you through it because would it be fair to say that what is written there is effectively your evidence? And I'll highlight certain parts.
That is correct, yes. On that specific paragraphs, although it's a limited response and only on limited issues in the statement.
I'm going to leave it to anybody who takes issues with that to deal with it with you in cross-examination. I just want to highlight, you've already indicated, as you do on page 9, 27, 3.4, that you weren't aware of any actual decision taken by Advocate Jiba not to review the withdrawal of the charges.
Yes, up to today I haven't seen an actual document or a memo or a letter of any kind where she actually makes a decision that she considered the memorandum and she makes a positive finding that she's not going to review because of A, B or C. I've never seen a document like that. I've never seen anything like that.
Okay. On page 10 of your affidavit, in paragraph 27.82, you relay what you had been informed as to what happened in the Magistrates Court when Advocate Smith had, in fact, sought to withdraw the matter as per his instructions.
Yeah, when it was relayed to me, and Advocate Smith made an affidavit which I provided to you, that when he withdrew the charges and he mentioned that they were being withdrawn provisionally, the legal representative of Lieutenant General Mrwebi took offense to that and stated, no, it's a permanent withdrawal, it's not a provisional withdrawal. The magistrate then said a withdrawal is a withdrawal until something further happens, and he wrote on the charge sheet in Afrikaans teruggetrek teen beskuldigde 1 en 2. But perhaps on that point I should just mention, one must remember we have the letter that Advocate Mrwebi sent to the representatives. He does not speak about provisional or permanent withdrawal, but one must remember that they made representations, and they based their representations on an abuse of the process by the police and the fabrication of evidence, etc. And when Advocate Mrwebi informed them he's read their representations and he's withdrawing the matter, I suppose they may have believed that he withdraws it on the basis of their representations, and that they may have been unaware that he was actually withdrawing it because of a completely different reason than they put in their representations. And they may have been under the mistaken belief that it was a permanent withdrawal.
Maybe to spare me the wrath of the presiding officers, the documentation to which is being referred to is dated 4 December 2011, and it is out of sequence, but it is in chronology. It would be marked 65I, but maybe I could just quickly read it to you. It is, I refer to your letter dated 17th November with regard to the above mentioned matter. I have considered your representation, and I've decided that the charges against your client, Lieutenant General Mluli, must be withdrawn. I have accordingly instructed the prosecutor to ensure that the charges are withdrawn immediately. Accordingly, I would suggest that you liaise with the prosecutor at the Specialized Commercial Crime Unit in Pretoria to take the process forward. I trust that the above is in order, and it's dated 4 December 2011. Did you see this letter prior to me showing it to you before?
No, not at all.
When you delivered this letter to Advocate Mrwebi, be it on the 23rd or the 24th of April, was the issue as to whether Advocate Breitenbach was the subject matter of a suspension decision or a suspension pending raised with you?
No, not at all, and also not during the meeting.
Was it raised by Advocate Breitenbach with you at all?
No, not at all.
And when you went to deliver these documents, this was at the NDPP head office, correct?
That is correct, yes.
So if anybody wanted to serve a document on Advocate Breitenbach, they would have been able to do it during your walkabout to deliver these documents?
Yes, we go to the desk, the reception desk. We ask that we want to speak to Advocate Mrwebi. They then phone him, and he sends somebody to come and collect us. In certain circumstances, I can't remember on that exact day, we know the path and we walked there, but we spoke to the person who I believed was the PA of Advocate Jiba. Close to her offices, we spoke to Advocate Mr. Hofmeyer, and we also spoke to Advocate Mrwebi. Any one of them could have raised the issue of the suspension letter with us.
Now you deal with this in page 12 of your affidavit, paragraph 27.9.3, and you say at paragraph 27.9.5, by that stage you had worked with her for approximately 12 years, and given your experience with her, she would have faced such a letter head on and not seek to avoid it in any way. You were with her, and that nothing gave you the impression that she was trying to avoid head office personnel.
No, absolutely, and I think anybody that know her, not even for 12 years, would get the same impression about her.
You then sum up in paragraph, right, you make a proposition in paragraph 27.10.3 that the removal and decisions taken had resulted in delays in prosecution. Why do you say that?
The problem is every time a prosecutor is removed from a case and replaced with another one, the new prosecutor must first study the docket, try to get up to speed, and then take the matter forward. So every time prosecutor is replaced, there is a potential for a delay, and unless there's very good reason, I believe the prosecutor shouldn't easily be changed. But that's the decision from the command structure within the NPA, and obviously we can enforce anything on them. But I mean, the removal of Advocate Smith and myself in August would definitely result in a delay. And that's the point I just make. I do not know why I was removed and why I couldn't be left to carry on, but I accepted it, and I didn't do anything further and handed over to Advocate Mashamite when I was removed.
In paragraph 28, and you've largely dealt with that in your oral evidence, you deal with the allegation that further guidance had not been given to the SAPs after the withdrawal of the Mluli case. Effectively, this was in response to the allegation that it was Advocate Breitenbach's task to provide those instructions. She didn't do it, and that's why the case stalled. Is that your understanding?
Yes, and I think in my affidavit, paragraph 28, I clearly make out the point that from the pen of Advocate Mrwebi himself, through the period of, and I make that point in 28.5, December 2011 to April 2012, he held the belief that his original decision was correct, that the matter was closed, and that it would not be in the interest of justice for the NPA to be further involved in this matter. The last communication was then 26 April 2012 when he acknowledged the receipt. The first time that I know from, not from personal view, but that he again engaged was when he asked Advocate Mokgoro to change the prosecutors and appoint a new prosecutor, which I think we dealt with the letter, and that was somewhere in August of that year. So between April and August, there was not a lot of pressure being placed. Well, I can say from December 2011, there was not a lot of pressure being placed by the Special Director on either Advocate Breitenbach, myself, Smith, or anybody else involved in the matter to finalize certain things, if there was things to be finalized.
Right. Now, you also happen to be, if we shift off the Mluli matter specifically, you also happen to have been the prosecutor who had been appointed to guide the investigation into the alleged wrongdoing by Advocate Jiba in relation to the perjury and corruption charges. Is that correct?
That is correct. That is dealt with from page 15 of the papers, as well as my affidavit. From paragraph 32 and further, I was requested by Advocate Hofmeyer, who obviously had spoken to the National Director, Mr. Nkasana, at that stage, and that's how I became involved.
Right. And at that stage, what was Advocate Hofmeyer's, he was the Deputy National Director dealing with?
Asset forfeiture matters. That was his portfolio. He started the asset forfeiture unit, and until he was removed from the asset forfeiture unit by Advocate Abrams, he was in charge of the asset forfeiture.
And Advocate Jiba was the head of the LAD. Now, you weren't at LAD yet.
I think she was National Prosecuting Services.
She was National Prosecuting
Services. Advocate Mokgoro
was LAD.
Not at Marshal Mokgoro. She was the... I'm not sure what her portfolio was now, but then there was another advocate that was part of LAD.
She was LAD.
She was LAD, sorry, you're quite correct. She was LAD.
So ordinarily, such a request would have gone to the NDPP, who's dealing with prosecutorial services, correct? But that happened to be Advocate Jiba.
Advocate Jiba, yes, that happened to be her. Although I'm not sure, but you must remember that the NPA Act does not describe the portfolios to the different people. And if you're a Deputy National Director, you have all the powers of a Deputy National Director. The fact that you ascribe a certain portfolio is at the behest of the National Director.
Right. And in your understanding, in your 30 years, does anybody have an entitlement to any portfolio?
No, they moved around at the behest of a person in a more senior position.
Right. Now, you were appointed and you then prepared a memorandum in this matter, correct?
That's correct. Sorry. That's correct, yes.
Just give me a moment. Right. The complaint that was laid was effectively laid by a staff member at the NPA, as I understand it, on the instruction of Advocate Nkasana, but that's not going to be you're dealing with it.
Well, one must also just remember that the NPA got the opinion of Advocate Pat Ellis from the Pretoria Bar, and that was also attached to some of the papers, I think A1.
Yes,
in the docket.
We will deal with Advocate Ellis's, Advocate Ferreira. I'm just trying to find your memorandum, which I had at the tip of my fingers yesterday and proceeded to lose. Just give me a... This is not in the hard copy documents before you, because I don't intend to take the witness, as I did in respect of the other ones, through it, but This memorandum is dated, it's an internal memorandum. It's to be found on page 34 in the Dropbox dealing with court records at 4.29. This is, and I have deliberately not taken it out of its original place. It constituted part of the Rule 53 record that had been provided in the review application that had been brought by Freedom Under the Law when they sought to review the decision to withdraw the charges which had occurred. And so the memorandum is located therein. And you have an opportunity, you've had an opportunity recently to have a look at that memorandum. Correct?
That is correct, yes.
Do you still believe that your views as reflected in those memorandum are your views?
That is correct, yes.
And in your view, there was a prima facie case to institute the prosecution?
That is correct.
Based on the evidence which is contained in that memorandum?
That's correct, yes.
Okay. And it's that evidence which would also be before this inquiry?
Yes. I also don't know if you want to deal with the aspect that in one of those earlier memorandums I raised the issue.
I'm coming with that in a moment. We're going to deal with that right last. So you had prepared this memorandum together with Advocate Gerard van Eden for Advocate Mrwebi in 2014, correct?
That is correct, yes.
Right. In fact, Advocate Jiba had been summoned and she'd appeared in court, and the matter was then postponed for trial, correct?
That is correct, yes.
Right. After such postponement, the NDPP changed and Advocate Abrams became the NDPP in June 2015.
That's correct, yes.
Right. And he then, as indicated in paragraph 36 of your affidavit, asked you for a briefing.
Yes, he did do so.
Right. Did you find that strange?
Yes, as I described in paragraph 36, the only two cases, high-profile cases or any type of case that I know that he had a briefing on, and obviously there may have been others that I was unaware, but the only ones I was aware was the one involving Advocate Jiba and the one involving Mrwebi.
It could be that those are the two cases you were involved in, and that's why he asked you, and you could have been asking other prosecutors for other cases.
No, in the Mrwebi matter I was no longer involved, and the briefing was given to him by Advocate Lowe and Advocate Rousseau. It wasn't given by me. I didn't even attend that meeting.
Right. And you say in 37 it was during this briefing that Mr. Hofmeyer was relieved of overseeing the team, and you were told to report to Advocate Marshal Mokgoro.
That is correct, yes.
Right. What was his rank?
He was a senior deputy director as I am.
So you're the same rank?
Yes.
Right. It was at that meeting that he then asked you to provide the memorandum to which I'm referring, correct?
That's correct, yes. One must just remember that at that meeting, which was 22 July, we did present him with a whole lot of evidence and documentation and things. But then after that presentation was made to him, he still said we must provide him with a legal opinion on the case of Advocate Jiba, which we duly did.
Right. The trial was then scheduled to commence on the 19th of August, and you had received no feedback on that opinion, correct?
That is correct. I've heard nothing from Advocate Mokgoro or Advocate Abrams, and obviously I didn't know what position I was in. I had to carry on with the trial on the 19th. Yeah. I inquired then from Advocate Mokgoro whether he's heard anything or what was the position, so that I can know whether I can prepare further and carry on with the trial.
If the bench looks at Annexure JF3 to Advocate Ferreira's affidavit, you will see the email exchange between Advocate Ferreira and Advocate Mokgoro, and you will see in the first line, I am still waiting for the decision, which probably corroborates the Provincial High Court's view as to who took the decision. Because Advocate Mokgoro says to Advocate Ferreira, hopefully a decision will be taken this afternoon or tomorrow morning. Doesn't say I've taken a decision. But So they were awaiting the words of Advocate Abrams. Right. Now, in the course of our consultations, I provided you with certain internal memoranda that had been provided by Advocate Mohatle, which is dated different dates, and they are attached at JF4, JF5, JF6 of your affidavit. Had you seen these prior to me giving it to you?
No, I've never seen them until you showed it to me and I attached it to my statement.
Right. And your views had never been sought in respect of this AFA memoranda?
No, I was never asked to comment on them or to provide an opinion based on what is contained therein.
Right. And are you surprised that you have 3 memoranda by the same prosecutor given within such a period of time where there are certain differences as to the reasons for the decision being taken reflected therein?
That is correct. I think in fairness to Advocate Mogatle, there was most probably pressure being placed on him from some sort, because in the first memorandum, he says that he believes that an outside person should be appointed from the Pretoria Bar to look at the decision, to make a decision about it. That then changed to the first memo of 17 August, which is JF6.
Could I just stop you for a moment?
Yes.
That you comment on page 34 is what he says. He recommends to review the decision and to recommend remedial action. Correct?
That's correct. If I can read
Right.
7.1, it is recommended that an African female senior counsel from the Pretoria Bar be appointed on an urgent basis to review the decision taken to prosecute Advocate Jiba and to recommend remedial action against any member of the NPA who might have been implicated in any wrongdoing.
Right. Now, when you initially got involved in this matter, and again the document isn't before you, but it is in folder J, number 18, right? You provided a memorandum. My initial reaction when I read this is a prosecutor trying to duck out of a case, but you explain your workload, and in that you essentially also express the view that an outside prosecutor should be dealing with this matter. Okay.
Yes, I think it was twofold. Firstly, my and Advocate Van Eerden's workload at that time played a role. And then secondly, because Advocate Jiba was the most senior ranked person in the NPA, and I was ranked a couple of levels below her, I then recommended that an outside counsel be appointed to firstly decide whether there is a case, and then if they decide there's a case, to prosecute the case. There was some discussion about it, but I think there was an uneasiness that you had to apply to the minister to make a Section 38(1) appointment, and I can't say whether it's Advocate Hofmeyer or Mr. Nkasana were not of the view that it may be positively received, and eventually nobody else was appointed, and Advocate Van Eerden and I had to still deal with the matter.
And if I quote what you say consideration could perhaps be given to appoint an outside SILT to give an opinion as to the fact whether there is a prima facie case or not on the anticipated charges, and Advocate Ellis was then asked to give that opinion and or to lead the prosecution in light of the fact that this is a case involving very senior NPA personnel, all of whom are more senior than Gerard Van Eerden and I. Do you still hold that view?
Perhaps I must just correct something. I'm not certain that the opinion of Advocate Ellis was actually, because that was in the docket, and I'm not sure that Advocate Ellis's opinion followed my advice to the NDPP. They may have independently already had his opinion at that stage.
You might not be aware of this, but in memory, your opinion there is dated 16th February 2015, and if I look at the memo received, from Advocate Ellis, it was dated I'll get one of my juniors to find it. I can't seem to lay my hands on it. No, you're entirely correct. It was dated 7th July 2014. So it was actually obtained prior to you giving your memorandum.
That is correct, yes.
Right. And you expressed your opinion as to the nature of the offence that had been committed, correct?
That is correct, yeah. There were several things that was being investigated, but ultimately this one set of facts culminated in the charge sheet produced.
And what involvement did you have, if any, in the decision that had been taken to withdraw the charges? How did you come to know about it?
The charges by Advocate
Abrams.
Okay, yeah. After my letter to Advocate Mokgoro, we were informed that there's a meeting at VGM, the head office of the NPA, on 18th September, the day before the trial was supposed to start. It was at 11 o'clock. Me and Advocate Van Eden went to the VGM office. We met with the NDPP. Advocate Mokgoro was present. Also the investigating officer, Lieutenant General Taiwed, I think. I can't remember whether there were other people involved. Advocate Abrams came in. He greeted us, thanked us for being present. He then informed us that Advocate Mokgoro has decided that the matter should be withdrawn. I then asked him and said, sooner or later a question may be asked as to how Advocate Mokgoro, who is the same rank as me, can review my decision. He then said, no, Advocate Mokgoro did not review my decision. He was asked to take an independent decision. I found it curious because it's still a review by another name perhaps, but that's not for me to decide.
You were then borne out by the High Court in that regard.
Yeah, Advocate Abrams then asked me and Advocate Van Eden to accompany him to a press meeting that was scheduled at 11:30 at VGM on the same day, which me and Advocate Van Eden declined.
Right. And after the withdrawal of the case, did you have anything further to do with the matter?
No.
Did you inquire about the matter again after the High Court decision?
Sorry, you're right. After the High Court decision, I went to Advocate Mokgoro and I think I wrote an email to him, or I spoke to him in person, and I said to him, the High Court has now found that the decision is reviewed, and obviously a question would be asked whether the matter should now be placed back on the roll. He informed me that the NPA would definitely appeal, and that any attempt to place the matter back on the roll would be premature for that reason. At this stage, as I said, I don't know if there's any appeal pending or whether any appeal was indeed made.
You expressed the view in your affidavit that it's not in the best interest of the NPA to have a senior member of the NPA embroiled in criminal litigation.
Yeah, look, I don't think it enhances the image of the NPA if its own people are criminally charged in courts.
Sorry, I don't think it enhances the image if their own personnel are prosecuted in courts.
I have no further questions, Advocate Ferreira. Sorry, there was one issue I forgot about. There is an annexure marked JF1 to your affidavit, which I had neglected to take you to.
I have it, yes.
Can you just tell us what is it?
This is a handwritten note by Advocate Mrwebi, in which he speaks, it's dated the 5th of December 2011, where he speaks about the perusal of the docket and the public prosecutor's report. Only he would be able to say when he drafted it, but it looks as if he drafted it after he received the report from Advocate Smith. I'm not always good at reading the handwriting, but in the middle of the first page it says, it appears that in his analysis of the evidence he does not take into account the fact that an acknowledgement of debt by Mdluli in favor of Atlantis Motors was signed. And then the last sentence, the amount of 42, around 42 plus K has been accounted for, and then I can't see meaning somebody is still liable. And then if one turns the page, he says, naturally the transaction appear irregular. That's on the third line, plus minus. And just above his signature, he ends off by saying, be that as it may, the main issue is the fact that the police did not have the mandate in this matter. And then on the bottom left-hand corner, he writes, nolly at this stage. And in my affidavit, I just explained that nolly means you refuse to prosecute. Because either there's no evidence or no crime was committed in your view. And yeah, that's, I think, the...
We'll get Advocate Mrwebi to read it to us better when he comes. Thank you, Advocate Ferreira.
Thank you, Advocate Bauer. Before we take a lunch break, because I think you might need it to confer also. You need the extra time to confer. Remember yesterday when we closed proceedings, there was a statement that from Advocate Masuku that a decision to prosecute had been taken by the NPA, isn't it? And this morning you came back with a correction of that statement. Can you kindly, just for the record, make that statement just for purposes of the record?
Sorry, you
Madam Chair,
sorry to Advocate Masuku Junior and I had come to you, and I'm not sure if you had told him we had.
When I say the record, I mean for recording purposes.
Yes, Madam Chair, our instructing attorney, Mr. Machavu, will deal with it because he is the one who has been communicating with the relevant officials on the matter.
Okay, thank you.
Thank you, Chair and fellow panelists. I think what I sought to convey to councils was the steps that we took in an attempt to comply with your directive.
Mr. Machavu, you're going to have to speak louder, sorry.
I beg your pardon. Am I loud enough? What I conveyed to council was the steps that we took in an attempt to comply with your order, with specific reference to getting certainty about a decision that we were informed by the spokesperson of the NPA that it had been taken. The difficulty that we all had at the time was that none of us had actually seen it. I dispatched a letter to the Acting National Director of Public Prosecutions at approximately 2:15 yesterday afternoon, in which we also attached a copy of your ruling and demanded an answer by no later than close of trade yesterday. A copy of it was also shared with the evidence leaders, and I'm happy to hand up copies. As at 5:05 in the afternoon yesterday, I had not yet received a formal reply to that pertinent letter. I then made further inquiries, and I was told that in fact that particular docket was sent to the DPP in Northwest to consider and make a decision. I then forwarded the same letter that I had addressed to Dr. Ramaite to that DPP in Northwest, and explained in the cover note, which I'll also hand up, that the reason I'm coming to them directly is that we have now run out of time to comply, and we are duty bound to advise the inquiry as to an answer one way or the other. I did not get a reply. The relevant DPP is Advocate J.J. Smith. At about 9:15 last night again, I addressed a further letter, which I will also hand up to Advocate Ramaite, and copied everybody, including the DPP, to demand an answer so that we are able to advise the inquiry in the morning as to what the status thereof is. To date, I am yet to receive a formal reply. What I did before we commenced this morning, I phoned the DPP's office in Northwest, and in fairness to Advocate Smith, I was informed that he is currently on leave. However, Advocate Gladstone Maema was the acting DPP in his stead, and I inquired from him whether or not he has been privy to the correspondence, and he confirmed in the affirmative that he had received my letter and that a written response would be sent to Advocate or Dr. Silas Ramaite, and would be copied so that I could then make it available. Incidentally, before this was put to me, I then checked on my emails again to check if the letter that was promised had in fact been sent, and it has not been sent. However, what Mr. Advocate Maema informed me was that he is aware, he was informed that a decision was taken. He would locate the docket and attach a signed decision which would then be dispatched to me. As matters stand, I have not received it. He did also inform me that a decision that he knows was taken was one that says they declined to prosecute. But it was not taken by him, it was taken by Advocate J.J. Smith. Until I receive it, personally, I am unable to take the point further than that. But I did confirm with him that in the fullness of time, I would have to place on record our discussion because I'm duty bound to do so. And copies of what we did, I'm happy to hand up during the lunch break. But that's as far as I can take it. Beyond the say-so that that decision was taken and it is one that says decline to prosecute, I truly, sincerely cannot take it beyond that. Mr. Mfaku, whom I spoke to again this morning as the NPA spokesperson, confirmed that he didn't wake up one morning and dream up that such a decision was taken and was taken by that relevant DPP, and he indicated that he's quite happy to confirm that if so called upon, because it's a fray that I did not want to get into. All we want is whether a decision is there or not, whatever it is. And extracurricularly, when we're having our own collegial discussions, I think Nazreen informed all of us in my presence that she had a call from Advocate Ramaite this morning, who confirmed receipt of my correspondence amongst others, but apologized for the lateness of response. But she says he told her that as far as he, Ramaite, is concerned, there is no such a decision. And if I'm misstating my colleague, she can correct me, which is why I went an extra mile to speak to all of these people with a view to placing it on record. And I undertake to make it available as and when we receive whatever we are to receive from Mr. Maema. And that's as far as I can take it, Judge.
Thank you so much, Mr. Majavu. And Nazreen, Advocate Bauer will probably confirm.
I confirm the telephonic conversation that Dr. Ramaite indicated that there has been no decision, and I understand that no decision has been relayed to Advocate Jiba formally as well.
Thank you. So I think because of the contradictory information, it is the more necessary that we get written confirmation eventually from the NPA. But thank you so much for the information. And
thank you.
I think we can adjourn for the lunch break, and also you will have an opportunity to confirm. Okay. We adjourn until 2 o'clock.